All right, let's jump right into this explainer. We are looking at a truly high-stakes legal showdown today. I'm talking about a case where an accused fraudster literally tries to legally checkmate the president of South Africa. This is the landmark year 2000 Constitutional Court case of Jürgen Harksen versus the President of the Republic of South Africa. It's a fascinating look at what happens when domestic legal procedures crash head-on into international law, and how a single signature can, well, almost spark a constitutional crisis.
To keep us on track and make sure we don't get lost in the legal weeds, here is our roadmap for the day. 1. The extradition problem. 2. The Extradition Act. 3. The constitutional challenge. 4. Domestic versus international law. And 5. The final verdict.
So, kicking things off with part 1, the extradition problem. Or, honestly, as I like to call it, no treaty, no problem.
Picture this. It's March 1994. The Federal Republic of Germany, the FRG, formally asks South Africa to extradite a guy named Jürgen Harksen. Harksen is a German citizen living in South Africa at the time, and he's wanted back home for some seriously heavy fraud charges. But there is a massive legal hurdle. You see, because of South Africa's historical policy of apartheid and its withdrawal from the Commonwealth way back in 1961, the country had suffered decades of intense international isolation. The result of all that? By 1994, South Africa had very few extradition treaties in place, and absolutely zero extradition treaty with Germany. Which brings up a pretty massive question. Can a country actually extradite someone if there is literally no formal treaty on the books?
Well, the answer from international law is actually pretty wild. It turns out, yeah, you absolutely can extradite without a treaty. International law has long recognized that this kind of cooperation can happen purely based on concepts called comity and reciprocity. Basically, this is just international cooperation based on sheer goodwill, courtesy, or mutual assurances between nations. So even without a formal binding treaty, Germany and South Africa were totally free to legally cooperate. But that begs the next question. How exactly does international goodwill translate into actual boots-on-the-ground local action?
And that brings us right to Section 2, the Extradition Act. Let's open up the domestic rulebook and see how it works.
South African law lays out 3 distinct ways an extradition can happen. First up, if there's a formal treaty in place, you use Section 3.1. Pretty straightforward. Now, if there is no treaty, you fall under Section 3.2. This one is the big one for us. It explicitly requires the president's written consent. And just for context, later on in 1996, they added a third option for designated states under Section 3.3, but that didn't apply when Harksen's process actually kicked off. So Harksen is sitting squarely in that second category. For Germany to get him, the president of South Africa himself has to personally sign a written consent. And in May 1995, after getting a memo from the Minister of Justice, the president did exactly that.
Now, you might be thinking the president's signature is the final word, right? Case closed? Actually, it's not. Think of the president's signature more like unlocking a door. It doesn't instantly put Harksen on a plane. It just triggers a pretty extensive 4-step domestic process. First, the minister has to notify a magistrate. Second, the magistrate issues a warrant for arrest. Third, an inquiry is held to ensure there's actually enough evidence to warrant a prosecution back in Germany. And finally, if the magistrate says yes, there's enough evidence, Harksen is committed to prison to wait for the minister's final decision on the surrender. So the president's signature? It literally just starts the clock on this whole domestic machine.
Which leads us to part 3, the constitutional challenge. This is where Harksen tries for a checkmate.
Harksen wasn't just going to sit back and let this happen. He launched a brilliantly clever, multi-pronged attack. He points out what looks like a glaring constitutional contradiction. On one hand, you have the Extradition Act, Section 3.2, which says the president can independently consent to extradition. Okay, fine. But on the other hand, Section 231 of the South African Constitution explicitly states that any international agreement only binds a republic after it has been approved by Parliament. So Harksen argues, hey, the president's written consent to Germany, that was effectively an international agreement. And since Parliament never voted on it, the president's action was completely unconstitutional, which would mean the entire extradition process was invalid.
And he didn't stop there. He doubled down using international law itself, specifically Article 46 of the 1969 Vienna Convention on the Law of Treaties. He brought up a concept similar to estoppel. If you're not familiar, estoppel basically means you can't legally go back on a representation you've already made. It's like saying, hey, you already promised. He claimed the president's consent signaled to Germany that an agreement was locked in. So even if the president bypassed his own internal constitution, Germany was led to believe a deal was a deal, tying the government's hands internationally. It's a really fascinating argument. He's essentially accusing the president of breaking the supreme law of the land just to make a handshake deal with a foreign power.
So did the president actually break the supreme law of the land? Let's get into Part 4, Domestic versus International Law, and check out the Constitutional Court's countermove.
Justice Goldstone, writing for a unanimous constitutional court, delivered an absolute smackdown to Harksen's argument. He wrote, and I quote, "It was a domestic act never intended to create international legal rights and obligations." Bam! That single sentence right there just entirely destroys the core premise of Harksen's entire argument.
Let's break down exactly why. Harksen's case relied on this idea that an international agreement was magically born the second the president signed that piece of paper. But the court wasn't having it. First off, they explained that the president's consent wasn't a promise to Germany at all. It merely brought Harksen under the purview of South Africa's Domestic Extradition Act, so a local magistrate could do their job and look at the evidence. Second, those procedures exist solely to protect the rights of people within South Africa. Third, when you look at the actual diplomatic notes sent from South Africa to Germany, they were literally just administrative forwards. Think of it like forwarding an email. They basically just said, your request has been forwarded to the relevant authority. There was zero formal substantive promise established. A purely administrative domestic signature cannot just magically transform into a binding international treaty.
All right, let's wrap up this explainer by moving to Part 5, the final verdict. Checkmate.
Think about the timeline of this case for a second. It reveals a staggering delay. Germany requested the extradition in March 1994. The president consented in May 1995. And this final constitutional court ruling? It didn't happen until March 2000. That is a 6-year marathon from the initial request to the ultimate resolution. It's a perfect example of just how incredibly drawn out and complex these high-stakes procedural battles can get when a well-resourced individual fights extradition at literally every single step of the way.
In the end, the court's final verdict was absolute. Harksen's appeal was dismissed on all merits. The whole Vienna Convention argument got thrown out because, well, as we established, there was never any international agreement for Germany to rely on in the first place. But here is a very fascinating twist. Harksen actually wasn't charged the legal costs of the appeal. Now, usually if you lose a massive case like this, you're on the hook for the winner's legal bills. But the court cited prior cases pointing out that extradition is essentially a criminal proceeding where someone's liberty is at stake. Because Harksen raised a genuine, substantial constitutional complaint, the court didn't slap him with the costs. They actually want to encourage real constitutional tests, even if the applicant ultimately loses.
Which brings us to the end of Harksen's attempt to checkmate the president. And I want to leave you with this thought to consider. If a president's signature in a case like this only unlocks the door to domestic law, where does a nation's true sovereign power end, and where does international law actually begin? It's this delicate, constant dance between local courts, constitutional protections, and the relentless demands of global justice. Thanks for joining me on this deep dive. Keep questioning and keep exploring the hidden mechanics of our world.